Carol Montgomery sued me over a fence that sat entirely on my own land. She was the president of Lakeside Estates HOA, and she had never once asked me for permission to use the private road that crossed my property every single day. That was her first mistake. Her second mistake was assuming I hadn't read every word of the plat map when I bought this place. The gate is up now, both ends, one set of keys, and they belong to me. Drop a comment telling me where you're watching from, because what happened next will make your jaw drop. I bought the lake ranch on a Tuesday in October, 7 years before any of this started. The closing took 4 hours, which is long by most standards, but I didn't rush it. I sat at that table in the title company's conference room and read every document they placed in front of me. The warranty deed, the survey, the title commitment, the preliminary plat map issued by Harlan County in 1987. The escrow officer glanced at her watch twice. I didn't notice. When you're acquiring 22 acres on the eastern edge of a glacial lake in rural Wisconsin, you read the paperwork. The property itself was exactly what I'd been looking for after 30 years of engineering work. Not grand, not showy. A long parcel running north to south, with the lake taking up most of the western boundary and a mixed stand of white pine and red oak filling the eastern corridor. The house was a 1970s ranch-style structure that needed a new roof and new windows, both of which I handled myself in the first 2 summers. There was a dock that creaked but held, a small equipment shed, and roughly 800 feet of gravel frontage along the water. I was 54 years old when I signed the deed. I planned to stay until I couldn't anymore. The eastern edge of the property ran along what the plat map labeled as Private Access Road, Parcel 7 Alpha. It was a dirt and gravel lane, maybe 14 feet wide, that entered from County Road G at the north and ran southward along my fence line, before curving east and disappearing into a gap in the tree line. I had driven it once during my due diligence visit. It was quiet, well-maintained in a basic sense, and clearly in daily use. Tire tracks, flattened gravel, the occasional candy wrapper in the ditch. The lane served as the only vehicular access to Lakeside Estates, the HOA development of 41 homes clustered on the inland side of the ridge. I noted this in my file, not with alarm, not with suspicion, just as a fact. The plat map showed the road clearly within the boundaries of Parcel 7 Alpha, which was the legal description of the land I was purchasing. No easement for third-party use appeared anywhere in the title search. I asked my real estate attorney about it before closing. She confirmed the road was mine. It had been mine with every prior owner going back to the original 1987 subdivision. Nobody had ever formalized a right-of-way agreement. The HOA had simply been using it, year after year, the way people sometimes use things that aren't theirs when nobody stops them. I filed that information away and moved on. I wasn't interested in conflict. I wasn't interested in leverage. I had a roof to replace and a dock to reseal, and the HOA community drove the road quietly enough that their presence registered only as background noise. I let it continue. That was my choice. What happened later was theirs. The fence project came up in my 3rd spring at the ranch. The southern end of my property had an erosion problem, a shallow ravine along the lower pasture that cattle from an adjacent parcel had been widening every season by wandering through. I contacted the county land use office, confirmed the appropriate setback requirements, selected a treated post and rail design that met local agricultural fencing codes, and submitted my building permit application in February. The permit came back approved in 21 days. I hired a 2-man crew from town, staked the line myself using the survey pins I'd located in my first year, and the fence went up over 4 days in April. It sat entirely within my property boundary. It did not cross the road. It did not touch the road. It did not affect any neighbor's view of anything except, arguably, the lower ravine, which had not been scenic to begin with. I did not inform the HOA. I had no legal obligation to do so. They were not my neighbors in any jurisdictional sense. Their covenant documents did not extend to my parcel, their architectural review committee had no authority over my land, and I was not a signatory to any HOA agreement of any kind. As far as property law was concerned, Carol Montgomery and her board of directors were strangers. She showed up on a Thursday afternoon in early May. I was on the south side of the property checking the new fence posts when I heard a car door. I walked up to the driveway and found a woman standing beside a white SUV, holding a manila folder and looking at the fence line with the expression of someone who had already made a decision and was now collecting evidence to support it. She introduced herself as Carol Montgomery, president of the Lakeside Estates Homeowners Association. She had a way of saying the full name of the organization, every word, every time, that suggested she found it important. She told me the fence was, in her assessment, a violation of community aesthetic standards and that it created what she called an unwelcome visual intrusion on the shared character of the corridor. I listened to all of it without interrupting. When she finished, I asked her one question. Can you show me which specific provision in your HOA covenant applies to property that lies outside your HOA's recorded boundary? She opened the manila folder. She turned 3 pages. She closed it. She said she would be in touch. She got into the white SUV and drove back up the private road that crossed my land, and I watched her taillights disappear into the tree line, and then I went back to checking fence posts. The letter arrived 11 days later. It came on the letterhead of a law firm in Madison, Whitfield, Crane, and Associates, and it was addressed to me as the property owner of record for the parcel adjacent to Lakeside Estates. The language was formal and dense, built to intimidate through volume rather than precision. It claimed that my newly installed fence constituted a violation of community development standards, that it was causing measurable diminishment of property values within the Lakeside Estates community, and that I was required to remove or substantially alter the structure within 14 days or face legal action. There were 4 pages of it. I read all 4 pages twice. Then I spread my plat map out on the kitchen table, weighted the corners with a coffee mug and a stapler, and looked at it for a long time. The fence line I had built was clearly inside my survey pins. My permit number was stamped in the county's system. The HOA's recorded covenant boundary was marked in the title documents. It stopped at the eastern ridgeline, well short of my property. I took photographs of the letter with my phone, time-stamped, and placed the originals in a manila folder of my own. I labeled it with a date and a single word: correspondence. I had no plan yet, I just had a folder. The pressure didn't stay confined to legal mail for long. Within a week of the letter arriving, there were posts circulating in the Lakeside Estates online community group. I knew about them because 2 neighbors, the Petersons from the far end of the development, called me directly. They were decent people, slightly embarrassed on behalf of their community. They told me Carol had framed the fence as an aggressive act, a deliberate attempt to wall off the natural beauty of the corridor. The word hostile appeared more than once. One post reportedly compared my fence to a spite structure. The Petersons wanted me to know they didn't personally agree. I thanked them and kept the call short. Carol held an emergency HOA meeting that Friday evening. I know this because the meeting notice was accidentally forwarded to me by a resident who thought he was replying to a different message thread. The agenda listed one item: response strategy, adjacent property encroachment. I was the encroachment. I saved that email to the folder. While Carol was organizing her community response on that Friday night, I was at my kitchen table with a laptop, pulling up the Harlan County Public Records portal and beginning a methodical review of every document associated with the road that ran through my land. I hadn't formed a plan yet, but I was starting to look at the thing I'd filed away at closing, and I was looking at it more carefully. The HOA's legal letter had introduced a level of formality into the situation that warranted a formal response. I called my real estate attorney on Monday morning. Not a new hire, not a specialist, just the attorney who had handled my closing and knew the file. I asked her to review the HOA's letter and render an opinion on my legal exposure. She called me back the next afternoon. Her assessment was brief. The fence was permitted, compliant, and sat within my recorded boundary. The HOA had no covenant authority over my parcel. The claim was without legal foundation. I asked her to draft a written response. She did. We sent it to Whitfield, Crane, and Associates by certified mail on a Wednesday. The response package contained 4 attachments. The county-issued building permit with its approval date and inspector's sign-off. The certified survey showing the fence line relative to the property pins. The Harlan County Assessor's written confirmation that my parcel was not within any recorded HOA jurisdiction, and a single-page legal analysis stating plainly that the demand to remove the fence had no enforceable basis. The cover letter was 2 paragraphs. The second paragraph noted that if the HOA chose to proceed with litigation, we would respond accordingly. Whitfield, Crane, and Associates went quiet for 8 days. No reply, no acknowledgement, no withdrawal of the original demand. Then, on the 9th day, they filed a civil complaint in Harlan County Circuit Court, formally claiming that my fence violated neighborhood character standards and requesting a court order compelling its removal. The filing fee alone would have cost more than the fence. I received a copy of the complaint by process server on a Thursday evening, signed for it at the front door, and brought it inside. Carol had escalated. The question was whether she understood what she had escalated into. I stood at the kitchen window looking out at the private road for a few minutes. Cars had come through twice while I was reading the complaint. Residents of Lakeside Estates going home for the evening, rolling over the gravel that ran through my land without slowing down, without a second thought. The way they had done every day for as long as anyone could remember. I noted the time. I went to the folder and added the complaint. Then I opened the county records portal again and kept reading. Let me stop right here, because I need you to feel what just happened. Carol Montgomery, who has 0 legal authority over Dan's land, sent a law firm after him for a fence that was fully permitted and sitting on his own property. 0 standing, 0 covenant coverage. She knew it, her lawyers probably knew it, and she filed anyway. Now, here's what I want to know. Did you catch the detail about the road? Because Dan did. Drop a comment right now. Where are you watching from? And stay locked in, because Dan hasn't played his hand yet. The camera system at the Lake Ranch was not installed because I expected trouble. I put it in during my second winter, when a black bear had been getting into the equipment shed, and I wanted footage for the wildlife office. 4 cameras total, 1 on the shed, 1 on the dock, 1 covering the driveway approach, 1 mounted high on the south corner of the house, with a wide angle that swept across the entire lower pasture and fence line. The system recorded continuously to a local drive and backed up to cloud storage every 6 hours. I mention this only because it matters for what comes next. I woke at 6:15 on a Wednesday morning in late June and walked the south fence as part of my daily check. The third panel from the eastern corner was missing. Not broken, not fallen, removed. The post was intact. The hardware was intact. And the 3 mounting bolts that had held the panel in place were lying in the grass, set down in a deliberate row, as though whoever had done it wanted to be tidy. The panel itself had been walked to the nearest oak tree and leaned against the trunk, face inward. This was not wind damage. This was not accident. Someone had come onto my land in the night, brought tools, and taken apart a portion of my fence with patience and intention. I went back to the house and pulled up the previous night's footage before I did anything else. The timestamp showed 11:47 p.m. A single figure, wearing dark clothing and carrying a canvas bag, came through the gap in the tree line from the direction of the road. The person moved without hesitation to the third panel, worked the bolts loose with a socket wrench, walked the panel to the oak, and left the way they had come. The camera angle was not sufficient to identify the individual with certainty, but the vehicle parked on the road at the edge of the frame, partially visible, rear quarter panel and plate, was identifiable. I paused the footage, zoomed, and wrote the plate number on a notepad. I did not call the sheriff immediately. I went outside first and photographed the scene: the empty post, the bolt hardware in the grass, the panel against the tree, the approach path where the grass had been compressed. I measured the distance from the road edge to the fence with a tape measure and noted it in my phone. Then I rebuilt the fence, reinstalled the panel, torqued the bolts to spec, and moved on. After that, I came inside, downloaded all footage from the prior 18 hours to an external drive, made a second copy, uploaded a third to a secondary cloud account, and then called the Harlan County Sheriff's Department to report criminal trespass and willful destruction of property. A deputy came out that afternoon. I gave him the footage drive, the photographs, and the plate number. He filled out a report and told me they would run the plate. The plate came back 2 days later connected to a landscaping contractor whose primary commercial client, as it turned out, was Lakeside Estates HOA. I filed that information in the folder. Before I had time to do much else, Carol appeared again. She showed up in the driveway on a Saturday morning, this time with another individual she introduced as our community surveyor, a title I did not recognize as a licensed professional designation. She announced that they intended to measure the fence to confirm its position relative to, and here she used a phrase that surprised me, the community's shared border. She said this with the certainty of someone who had already decided the outcome of the measurement. I stepped to the gate at the end of the driveway and held it closed with one hand. I told her, calmly and without raising my voice, that she did not have permission to enter my property to conduct any survey of any kind, and that if either she or her companion stepped past the gate, I would call the sheriff's department and report trespass. I told her that if she believed she had a legal basis for access, she was welcome to seek a court order. Carol's expression shifted, not to embarrassment, not to uncertainty, but to something harder. She told me I was making a serious mistake. I told her I appreciated her concern. She left. That afternoon, she sent an email to every Lakeside Estates resident describing our exchange. I know its contents because the Petersons forwarded it to me. The email characterized me as aggressive and unwilling to cooperate with reasonable community requests. It called the fence a deliberate provocation and announced that the HOA board had voted to pursue the civil case to its full conclusion. What the email did not mention, what Carol could not have known, was what I had already found in the Harlan County Public Records portal the previous week, and what I was quietly confirming, one document at a time, with a phone call I had placed that same morning. Not to my attorney, to the county assessor's office. I had asked them to pull the original subdivision plat from 1987, the one that showed exactly how the private access road had been classified at the moment the land was first divided. I was still waiting for the answer, but I had a strong sense of what it was going to be. I drove to the Harlan County Assessor's office on a Tuesday morning and parked in the lot at 8:55, 5 minutes before they opened. I had called ahead and spoken with a records clerk named Gerald, who had pulled the relevant files and set them aside. I brought a legal pad, a fine point pen, and a portable document scanner no larger than a hardcover book. I did not bring my attorney, not because the visit was informal, but because I wanted to read the documents myself before anyone else interpreted them for me. Gerald brought the file out on a rolling cart. The original 1987 plat for the Harlan Lake subdivision was a large format document, printed on drafting paper that had gone amber at the edges. It showed the entire original parcel, 814 acres that had been subdivided by the original landowner, a holding company called Northland Development Associates, into the lots that would eventually become both my property and the Lakeside Estates development. The road was there, drawn in a dashed line with a notation beside it. I read the notation twice. I read it a third time to be certain. Then I scanned the entire page at full resolution and moved on to the transfer documents. The notation read, Private Access Road, Parcel 7 Alpha, for exclusive use and maintenance of Parcel 7 Alpha owner. No public dedication. No common ownership transfer. That language was written into the plat in 1987 and by Northland Development Associates before a single house had been built in Lakeside Estates. The road had been designed as an internal service road for the large parcel, the parcel that became, after multiple resales and a boundary adjustment in 1994, the land I now owned. It had never been dedicated to public use. It had never been transferred to the HOA as common property. It had never been subject to any recorded easement granting third-party access rights. Over the following 3 hours, I worked through the chain of title with Gerald's help. Each deed transfer was pulled in sequence. Northland to private buyer in 1991, private buyer to a second family in 2001, second family to the predecessor from whom I had purchased in 2017. I checked every deed for easement language. I checked the HOA's recorded covenants and bylaws, which Gerald also had on file, for any mention of road access. I found nothing. No recorded easement, no license agreement, no right-of-way deed, no adverse possession claim ever filed. The HOA had been using a private road without any legal instrument authorizing that use. Not for 1 year. For more than 3 decades. I scanned everything, 112 pages total, drove home, and called my attorney. I laid it out for her in sequence, starting with the plat notation and ending with the unbroken chain of title. She was quiet for a moment after I finished. Then she said, "Dan, you own that road, all of it, and there is no easement." I told her I knew. I asked her what the proper legal process would be if I wanted to exercise my right to restrict access. She walked me through it. Written notice to all affected parties citing the legal basis, filing of a notice of intent with the county, application for the appropriate construction permits for any gates or barriers, and a minimum advance notice period before physical closure. No court order required. No HOA approval required. No negotiation required. The right was mine by deed. I asked her to draft the notice letter while I handled the permit applications. I submitted gate permit applications to the county the following morning. One gate at the northern end of the road, where it met County Road G, and one at the southern end, where it opened into the Lakeside Estates internal street network. Both applications cited the plat map and the chain of title. Both were submitted with the full documentation package. The county permit office reviewed and approved the northern gate in 6 business days. The southern gate approval came 4 days after that. I received the physical permit documents in the mail, filed them in the folder, and set a construction date. While I was doing all of this, Carol Montgomery was doing something else entirely. Her attorney at Whitfield, Crane and Associates had filed a motion in the circuit court requesting a preliminary hearing date on the HOA's complaint about my fence. The court scheduled the hearing for 8 weeks out. Carol, by her own account in a subsequent community email, interpreted this as progress. She sent another message to Lakeside Estates residents that same week describing the upcoming hearing as an opportunity to hold the adjacent landowner accountable. She used that phrase, adjacent landowner, as though my existence were an intrusion. She had no way of knowing what I had found in the plat records. She had no way of knowing what I had already permitted, already scheduled, already planned. The folder on my kitchen table was getting thick. The construction date was circled on my calendar in red, and the morning I had set aside to make one final call to the contractor who would install the gates was still 6 days away. Pause. Because what Dan just found inside that 1987 plat document is not a loophole, it is the foundation of his entire property title, hiding in plain sight for over 30 years, while an entire HOA community drove across his land without a single piece of paper authorizing them to do it. No easement, no right-of-way, nothing. So, here's the question I want you to think about before the next chapter. What would you do with that information? Comment below. And brace yourself, because Dan already has a construction date on the calendar. 3 days before the scheduled construction date, my attorney sent the formal notice letters by certified mail. Every household in Lakeside Estates received one. Carol Montgomery received 2, one as a resident, one in her capacity as HOA board president. The letter cited the 1987 plat map by document number, confirmed the absence of any recorded easement, and stated plainly that Dan Reynolds, as sole owner of Parcel 7 Alpha, intended to exercise his lawful right to restrict vehicular access on a specific date, 14 days hence. It included my attorney's contact information for any party wishing to discuss a formal access agreement. It did not invite argument. Carol called my cell phone within 2 hours. I let it go to voicemail. She left a message that lasted 4 minutes and 20 seconds, which I saved and time-stamped. It moved through disbelief, indignation, and something intended to sound like a warning. She used the word unconscionable twice. I listened once, noted the timestamp, added a transcription summary to the folder, and called the gate contractor to confirm the installation schedule. The HOA's legal response came fast. Whitfield, Crane, and Associates filed an emergency motion for a temporary restraining order to prevent the gate installation. They argued implied easement by prior use. My attorney submitted a response brief the same day, title history, plat documentation, and Wisconsin case law on implied easement standards. The judge denied the TRO by end of business Friday. The written order cited one central fact: the 1987 plat notation explicitly excluding third-party use had foreclosed that argument for 37 years. The HOA then filed a complaint with the county permit office claiming my gate approvals had been issued in error. The permit office reviewed the file and confirmed both approvals were correct. I received their written response and added it to the folder. The installation crew arrived at 7 a.m. on a Tuesday. 2 trucks, a post-hole auger, a concrete mixer, 4 workers, and permit copies clipped to their job folders. I walked both gate locations with the foreman, confirmed setback measurements against the permit drawings, and stepped back. The northern gate went in first. Steel posts set in concrete, a 16-foot powder-coated swing gate, a heavy-duty keyed lock, and a sign reading, "Private property, no trespassing, access by authorization only." Concrete poured by 9:30. Northern entrance closed by 11 a.m. for the first time in the property's recorded history. Carol arrived at 11:45. She pulled onto the shoulder of County Road G, got out, and stood at the new gate before telling the crew to stop. The foreman looked at her, looked at his permit folder, and kept working. She called the sheriff's department. A deputy arrived, reviewed both permits, confirmed the work was lawful, and asked Carol to step back from the active work zone. She stood at the roadside for another 40 minutes, phone to her ear, watching. The southern gate was completed at 4:50 p.m. 2 gates, 2 locks, 1 key ring, mine. That evening, my phone rang repeatedly between 5:30 and 8 p.m., residents of Lakeside Estates, unable to reach their homes by the only road they had ever used. I answered every call and said the same thing each time, without variation. I understand this is inconvenient, and I'm sorry for the disruption. If you'd like to discuss a formal access agreement, please have your attorney contact mine. The contact information was in the notice letter sent 14 days ago. When each caller finished, I said goodnight. Carol's community meeting reportedly lasted until 11 p.m. I was in bed by 9:30, listening to the lake. The first week after the gates went up had a particular quality to it, a pressure that was building somewhere I couldn't directly observe, like weather forming on the other side of a ridge. The HOA filed 2 more motions in circuit court, both of which my attorney handled without requiring my involvement. The first sought a declaration of implied easement based on continuous community use. The second requested emergency injunctive relief on the grounds of irreparable harm to property values. Both motions were denied within the same week. The judge's written orders were brief and consistent. No easement had been recorded. The plat language explicitly foreclosed implied easement arguments. and the hardship to the HOA was the result of a legal situation of their own long-term making, not of any wrongful act by me. Carol attempted 2 additional angles simultaneously. She contacted the Harlan County Board of Supervisors to argue that the road should be reclassified as a public thoroughfare based on decades of community use. The county's transportation planner reviewed the request, consulted the 1987 plat, noted the explicit non-dedication language, and returned a written response declining to pursue reclassification. Carol also reached out again to the regional press, this time with a more pointed narrative: a community held hostage by one man's property dispute. The reporter who had covered the original story called my attorney for comment. My attorney sent the same PDF I had sent before, updated with the 2 additional court denials. The follow-up story ran shorter than the original. The framing did not hold up against the documents. Through all of this, I kept the road closed. Residents had found alternative access, a longer route through the development's rear maintenance easement, unpaved and inconvenient, but passable. I had not blocked that route. I had not interfered with anyone's ability to reach their home by any legal means. What I had done was close a private road that had no legal authorization for third-party use. The distinction was important, and every court filing in the case had confirmed it. Still, I kept the cameras running. I had learned by that point not to assume that clarity of legal position would translate into restraint on the other side. The footage from the night of the 14th day showed activity beginning at 11:18 p.m. 2 figures approached the southern gate from inside the development, on foot, carrying what the camera resolved as a canvas bag and a handheld tool. The taller of the 2 figures worked on the lock for approximately 4 minutes before producing what appeared to be an angle grinder. The grinder ran for 40 seconds. The lock cylinder came apart. The gate was pushed open. Both figures returned inside the development, and a vehicle, a dark-colored SUV, drove through the open gate and out toward County Road G at 11:41 p.m. The camera captured a clear, well-lit image of the SUV's rear plate as it passed beneath the mounted floodlight I had installed at the gatepost during construction. I had positioned that light for exactly the kind of low-visibility recording situation that occurs at midnight. I discovered the damage at 6 a.m. The lock was destroyed beyond repair. The gate had been pushed partially off one hinge, and there were fresh gouge marks on the steel post where the grinder had slipped. I photographed everything before touching it. I called the Harlan County Sheriff's Department, and this time I did not wait. I requested a deputy and told the dispatcher I had surveillance footage of the individuals responsible. 2 deputies arrived within the hour. I handed them a copy of the footage on a USB drive and provided the plate number from the final frame. One deputy watched the footage twice. He wrote the report himself, noting, "Criminal damage to property, criminal trespass, and potential felony property destruction, given the replacement value of the gate hardware." He told me the plate would be run immediately. The plate was registered to a vehicle belonging to Carol Montgomery. I did not say anything when the deputy told me that. I nodded and asked him what the next steps in the investigation would be. He explained the process. I thanked him and went back inside to call my attorney. She picked up on the second ring, and I described what I had found and what the footage showed. There was a pause. Then she said, "Dan, I think we need to talk about adding to the civil complaint." By afternoon, my attorney had drafted an amended counterclaim that we would file in conjunction with the ongoing fence litigation, adding trespass, criminal mischief, abuse of civil process, and a claim for punitive damages against Carol individually, separate from the HOA. I replaced the destroyed lock that afternoon with a hardened steel model rated for industrial use. I also added a second camera at the southern gate, positioned lower, with a wider field. Then I updated the folder, which now required a second manila sleeve, and I put the court date on my calendar in red. The original fence complaint hearing, now carrying everything else with it. I have to say this plainly. Carol Montgomery had every opportunity to stop. She could have stopped after the first letter. She could have stopped after the TRO was denied. She could have stopped after 2 more motions were thrown out. Instead, she drove to a gate on someone else's private property at 11 p.m., watched someone cut through a lock with an angle grinder, and then drove her own registered vehicle through the opening, directly past a floodlit camera mounted at eye level. Dan didn't set a trap. He installed a light. Carol walked into it herself. The court date is coming. Stay right there. The Harlan County Circuit Court hearing was scheduled for a Tuesday at 9 a.m. I arrived at 8:30 with my attorney and a banker's box containing 2 organized binders, one for the fence complaint, one for the counterclaim. The courtroom was a standard mid-sized county room, wood-paneled, fluorescent lit, with a gallery that held perhaps 40 people. By the time the session was called to order, the gallery was full. Roughly 30 of the people seated there were Lakeside Estates residents. They had come, I assumed, because Carol had organized it. Another community show of force, the same instinct that had driven every prior decision she had made since May. What she had not organized for was what was inside my binders. Judge Patricia Morrow presided. She was direct in her manner and ran a tight calendar. The HOA's case was called first, as the original plaintiff. Whitfield, Crane, and Associates presented their complaint about the fence, the aesthetic impact, the community character argument, the diminishment of shared property values. The presentation was polished and took approximately 20 minutes. When they finished, Judge Morrow looked up from the file and asked a single question, directed at the lead attorney. Is the defendant a member of the Lakeside Estates Homeowners Association, or is his parcel subject to the HOA's recorded covenants? The attorney answered that the defendant was not a member, and that his parcel was not within the HOA's recorded jurisdiction, but argued that the fence nonetheless affected community interests. Judge Morrow made a note. She asked no follow-up questions. She turned to my attorney. My attorney presented the fence defense in 8 minutes. She submitted the building permit, the certified survey, the assessor's written confirmation of parcel jurisdiction, and the legal analysis letter we had sent to Whitfield, Crane and Associates the previous spring, the one they had received, and then filed a lawsuit anyway. Judge Morrow reviewed each document as it was entered. She asked one clarifying question about the survey methodology. My attorney answered it. The judge made another note, set the documents down, and said, "The plaintiff's complaint regarding the fence is dismissed with prejudice. The fence is lawfully placed, lawfully permitted, and the HOA has produced no instrument giving it jurisdiction over the defendant's property." She said it the way you might announce the weather. The HOA's lead attorney wrote something on his notepad. In the gallery, there was a shift. Not noise, just movement, people adjusting in their seats. Then my attorney stood again and presented the counterclaim. She began with the abuse of civil process count, the evidence that Whitfield, Crane, and Associates had received our complete legal response package, including the assessor's confirmation, before filing the original lawsuit, and had proceeded anyway. She presented the certified mail receipt, the response package contents, and the filing date of the complaint. She moved to the trespass counts, the night footage of the fence panel removal in June, the deputy's report, the contractor plate linked to the HOA. She moved to criminal mischief, the southern gate footage, the angle grinder, the plate of Carol's vehicle captured at the floodlit exit frame. She connected each piece of footage to a specific date, a specific sheriff's report number, and a specific dollar figure in property damage. The total across both incidents came to $9,240 in documented damage and replacement costs. Then she asked the court's permission to display the gate footage on the courtroom monitor. Judge Morrow granted it. The footage ran for 90 seconds. The 2 figures, the grinder, the gate swinging open, the dark SUV rolling through, the rear plate catching the floodlight in sharp resolution as the vehicle passed. The courtroom was very quiet. Carol Montgomery was seated at the plaintiff's table 3 feet from the monitor. She did not look at the screen during the playback. My attorney noted for the record that the plate number matched the vehicle registered to Carol Montgomery, and that the sheriff's department had an open investigation file bearing that plate number. She then called Carol to the stand. Carol's testimony lasted 40 minutes. Under direct questioning, she confirmed that she had known my parcel was outside the HOA's jurisdiction when she sent the initial demand letter. She confirmed she had authorized the first fence panel removal, characterizing it as a community safety inspection. She initially denied presence at the gate on the night of the lock destruction, then acknowledged, when shown a second camera angle my attorney had held back until that moment, that her vehicle had been present. She did not directly admit to directing the cutting of the lock. She did not need to. The footage, the plate, the timeline, and her own prior admissions formed a structure that required no further interpretation. Judge Morrow watched the second camera angle twice. When Carol stepped down from the stand, she did not look at the gallery. 30 Lakeside Estates residents looked at her, and then at each other, and then at the floor. Judge Morrow set the damages hearing for 6 weeks out and referred the criminal footage to the county district attorney's office for review. She noted on the record that the court found the counterclaim well documented and that the plaintiff's decision to proceed with litigation after receiving full notice of the legal defects in their position would be a factor in the damages assessment. Court was adjourned at 12:40 p.m. I packed the binders into the banker's box, thanked my attorney, and carried the box out to my truck. The damages hearing 6 weeks later lasted one morning. Judge Morrow reviewed the documented figures, legal fees, property repair costs, and the punitive damage request, against the record established at the first hearing. She awarded $44,800 in compensatory damages covering my legal fees from the date of the original unfounded demand letter through the conclusion of the fence complaint. She awarded $9,240 in property damage restitution for both incidents of physical destruction. For punitive damages, she assessed $15,000 against Carol Montgomery personally, separate from the HOA entity, citing the deliberate nature of the trespass and property destruction, and the decision to pursue litigation with prior knowledge of its legal deficiency. The total judgment came to $69,040. The HOA's insurance carrier would cover the entity portion. Carol's personal share would not be covered by any policy. Her attorney confirmed this to the court without elaboration. The criminal side moved more slowly, as it always does. The district attorney's office reviewed the footage and the sheriff's investigation file and filed charges approximately 9 weeks after the original hearing. Carol Montgomery and one other individual, identified through the sheriff's investigation as a maintenance contractor with prior ties to the HOA, were each charged with criminal damage to property exceeding $2,500, a Class 1 felony under Wisconsin statutes, and criminal trespass. The criminal case proceeded on its own timeline, separate from the civil matter. Carol entered a plea agreement 4 months later. 1 count of misdemeanor criminal damage to property, a fine of $3,500, 2 years of probation, and a requirement to complete a community service program. The felony charge was reduced as part of the agreement. The record remained. Misdemeanor or not, it was a criminal conviction, and it was public, and it was searchable by anyone who cared to look. The HOA held a special meeting the week after the criminal charges were filed. I was not there, but the Petersons called me afterward. Carol Montgomery resigned the presidency before the vote to remove her could be completed. The board elected an interim president, a retired school teacher named Marilyn Vogt, who, by the Petersons' account, had opposed the original fence complaint from the beginning but had been outvoted. Marilyn reached out to my attorney's office the following week to inquire about the possibility of a formal road access agreement. My attorney relayed the inquiry to me. I thought about it for 2 days before I responded. The negotiation took 3 weeks. It was conducted entirely through attorneys, in writing, without a single direct conversation between me and any HOA representative. The result was a recorded easement document, the first legally valid instrument ever to grant Lakeside Estates any access right over the private road. The terms were mine to propose, subject to negotiation, and the final agreement reflected that reality without being punitive. The HOA would pay an annual access fee of $4,800, payable in 2 installments, for the right to use the road for residential traffic. The agreement ran for 5 years, renewable by mutual consent. I retained the right to temporarily close the road for maintenance with 48 hours notice. I retained the right to terminate the agreement if any resident was found to have committed a criminal act on my property. Both parties signed. The document was recorded with the Harlan County Register of Deeds on a Thursday afternoon. It was assigned an instrument number and entered into the public chain of title. For the first time in 37 years, the road had a legal foundation. I used the first access fee payment, when it arrived, for 2 things: a full reseal on the dock, which had needed it for 2 seasons, and a new motion-activated floodlight at the northern gate to replace the temporary model I had installed during the dispute. The southern gate got a fresh coat of paint, the same powder coat color as the original, which had been scratched during the grinder incident. The replacement lock, the industrial-grade hardened steel one, stayed. I saw no reason to downgrade. The fence along the southern pasture stood exactly where I had built it. No one had filed anything about it since the day Judge Morrow dismissed the complaint. The ravine below it had stabilized over 2 seasons, which had been the point of the fence from the beginning. On the first Saturday in October, 2 years almost to the day from the morning Carol had stood in my driveway holding that manila folder, I was on the dock when a car came through the northern gate, slowed at the camera post out of what had become apparent habit, and continued down the road. The access card reader I'd had installed during the easement negotiation registered the entry and logged it automatically. The system was passive, unattended, and worked without my involvement. I watched the car disappear around the curve in the tree line, then turned back to the water. The lake was flat that morning. Mist was sitting in the low places on the opposite shore. I had a cup of coffee going cold in my hand, and approximately nothing that required my immediate attention. That was the point of all of it, really. Not the easement, not the judgment, not the gate. Just this. The quiet that comes when every boundary is where it belongs. So, let's talk about what actually happened here, because this story is genuinely instructive, and the lessons are ones you can use starting today. Read your property documents completely before you close. The plat map, the deed, the survey, every attachment, every notation, every footnote. Most buyers skim these and trust that the title company caught everything important. Sometimes that's fine. Sometimes, as Dan's situation shows, a single notation on a decades-old plat document is the difference between owning a road and not knowing you own one. The information was always there. Dan just read it. Second, an HOA's authority ends at its recorded boundary. If your property is not inside the HOA's covenant area, their rules do not apply to you. If you are ever told otherwise, ask for the specific provision, in writing, that grants the authority being claimed. If it doesn't exist, you will know immediately, because the answer will be silence. Exactly what Carol produced the first time Dan asked her directly. Third, documentation is infrastructure. Dan didn't timestamp every letter and back up every footage file because he had a plan. He did it out of habit. That habit became the foundation of his entire legal case. Build your records before you need them. And the final lesson, the one that matters most, is this. You do not need to set a trap for someone determined to walk into their own consequences. Dan secured his property lawfully and let Carol make her own decisions. Every choice she made after that first conversation was hers alone. The legal system simply recorded them all. If this story hit close to home, share it with someone who needs to hear it. And if you have ever dealt with HOA overreach or a property dispute that finally resolved the right way, tell us about it in the comments. We read every single one.